A trust account becomes necessary if the broker is going to hold client money for any reason. While sales transactions typically include a title company that will hold funds, there are cases where a title company is not used or is not convenient. At the time there is a written offer. Note that title companies do not participate in rentals. Thus, when a tenant provides a deposit check when applying for a rental, the broker must deposit that check in accordance with what the lease or the application says. The typical choices are 1. Hand over to the landlord. 2. Deposit in the broker's trust account. Assuming all parties agree that the broker will hold those funds, the broker must deposit that check and hold that money in trust. The broker may release those funds with the approval of the parties, again, per the lease. The lease might further state that all refundable deposits and non-refundable fees be held by the broker's trust account. Again, if all parties agree and the broker is willing to serve in that role, that money must be deposited to the broker's trust account and never to the general sales brokerage account, and never, and we do mean never, to any account held by a licensee. A broker does not need a property management trust account to hold the rental deposits as described above, and actually does not need to be managing the property to act as the listing or leasing broker on a rental. All of these activities fall under the role of the listing broker or leasing broker and do not qualify as property management. Even holding the refundable deposits can be done without being a property manager and can be deposited into the brokerage's general trust account. This subject is often confusing to agents on both sides of a lease and to the broker. A broker that does not engage in property management might be reluctant to hold the tenant's money in the general trust account, believing that such action constitutes property management. It does not. Nevertheless, the agents must determine which broker, the listing or leasing broker, will hold the money, and if neither wishes to do so, the tenant should make all the checks payable to the landlord. Once a broker and his licensees understand what point they stop being the listing or the leasing agent and start becoming the property manager, they will understand what needs to happen next. Any broker that does not allow property management in her firm should supervise the agents and instruct them on how far they can go before they stop being the listing agent and start being the property manager. Property management carries inherent risk. Doing property management properly with the required management agreement, diligent accounting in the trust account, and handling tenant-landlord issues is hard enough and risky enough. Doing it without realizing that property management is being conducted, without the correct agreements and poor accounting, will almost certainly result in problems. A broker would be in violation of ADRA if a licensee acting as a property manager without a valid property management agreement. Any broker that does not allow property management should do several things to protect the firm. Include a section in the Policy and Procedure Manual indicating that the firm does not allow property management. While explaining that the licensees may not act as property managers, the broker should identify the typical activities that go beyond the role of a listing agent that constitute property management and get licensees and the broker in trouble. Include a note or memo to the licensee when they turn in a listing for lease or a lease file. That memo should be a reminder of those activities that create a property management situation and ways to avoid that from occurring. Under a property management agreement, may a broker write a check from the trust account to pay a vendor who did a repair? Yes, assuming several factors. 1. The broker has sufficient funds belonging to the owner to pay the vendor. If the vendor is looking for $477 for a plumbing repair, the broker must verify that at least that amount of the total funds in the trust account belongs to that owner. 2. The broker has authorization from the owner in the property management agreement to pay vendors. 3. The vendor provided a proper invoice to the broker. 4. The broker may, assuming that the owner has empowered him to do so, pay any invoice or bills due from the trust account on behalf of the owner. That could include mortgage payments, utilities, taxes, repairs, and maintenance, etc. Since the statutes do not require or prohibit the payment of various items from the trust account, The property management agreement should be specific as to which bills the broker will pay and which bills the owner will pay. Many brokers will pay vendors, utilities, and similar bills. On the other hand, brokers' property managers are often reluctant to pay the mortgage, taxes, or HOA fees from the trust account. Thus, the agreement should be specific as to which items will be paid by each party. Trust account violations by a broker or anyone authorized by the broker to handle the trust account are a surefire way to get into trouble with ADRI. The Commissioner has made it clear to the real estate community that ADRI will view any shortages of client funds in the trust account as embezzlement, which is a felony. A felony could cause the licensees to have their licenses revoked, and they could be charged with a criminal offense. In a small firm, the broker or the owner might be able to supervise all deposits into and withdrawals out of the trust account, but that becomes difficult in a larger firm. A broker with a property management trust account should implement security measures, such as the following. Checks of any amount require 2 signatures, with at least 3 people having the authorization to sign checks. Hire an accountant or bookkeeper to routinely review the trust account and conduct the monthly reconciliation. Verify that the owner of the property has authorized every check. Such authorization should be in the property management agreement or in specific communication between the client and the licensee. Require that any authorization to pay a vendor or third party to be in writing and submitted with the request for payment from the licensee. Have a standard form for the licensees to use to request payments to a vendor, payment of agent fees, or any other payments out of the trust account. Periodically ask the licensees who are conducting property management to provide the broker with an accounting of the client's funds, to compare that with the broker's accounting. Obviously, those statements should match, so it is a good checks and balance. ADRI has uncovered many brokers, employees, and other staff members stealing from the trust account, so licensees who are property managers should be just as careful to monitor the broker as the broker is in monitoring the licensees. When ADRI finds a shortage, as they have done in recent years, a broker might have already disappeared with the money. Yet the licensees find themselves in the position of having to explain to their clients that their money is gone. In policy and/or practice, a broker cannot envision every possible issue, but by having specific safeguards in place, it tells anyone who might otherwise have ill intent that the brokerage will be watching and will not tolerate such activity.